Hello, everyone, and welcome to our webinar, Understanding Your Covenants, Mastering Your HOA and Your Condominium Association Rules, Enforcements, and ARCs. Thank you for joining us today. My name is Zuli Marabona, partner with KWPMC. I'm delighted to be here with you. I'm joined by my colleague, Alex Martin, who will be on shortly, having some technical difficulties this afternoon. Happy Wednesday, and before we dive in, I'd like to go over a few housekeeping items for everyone. The session will last approximately an hour. We're going to have a Q&A session or chat open. So please, if you're joining us and you have questions throughout the session, please do not hesitate to ask away. We will also have a poll question right before we begin, and we will do our best, as we always do, to answer all of your questions throughout our session. It is important to share that the information we cover today is for informational purposes only. Please do not take any of the information that we share, questions that we answer, legal in nature or not, as professional legal advice. We always recommend that you consult with your association counsel and other professionals such as accounting and beyond for your association. As we know, it is not a one-size-fits-all, and each association is unique. And I would normally turn it over to Alex, so I'm going to put on my Alex hat today. Without further ado, I'm going to turn it over to our expert panelists, and we're very excited for our panel here today. So I'll turn it over to you, Gary, first, and just a quick introduction and a little bit about you, and then over to Bruce.
Absolutely. Thank you, Zuli. So I'm Gary Mars. I'm a partner with the firm Siegfried Rivera. I've been practicing for just shy of 34 years. I'm a South Florida native and very happy to be residing still in the same general Northeast state environment where I grew up. So it's, feeling very hometownish and love to work with, people in this area. It's been really great from a career standpoint. Our firm, just as several of you probably are aware, but just in case you don't, is full service community association practice. We do everything from, the most minor violations all the way up to large scale construction defect litigation for our condo and homeowner association clients. We've been practicing for well over 40 years as a community association law firm and have about 52 or 3 attorneys. Principally Miami-Dade County, Broward, and Palm Beach is our focal point. We have offices in Coral Gables, in Plantation, and in West Palm Beach. So it's a pleasure to be here with KW today, and we look forward to trying to provide some good information and have a good dialogue. So thank you for having us.
Wonderful, Gary. Thank you so much for being with us today, and our very own Bruce Meja.
So good afternoon, everybody. It's a pleasure to be here with all of you, with Gary, and looking forward to the questions. Just a little bit about me. I've been in this business for a little over 22 years. I am one of the regional vice presidents and equity partners of KW Property Management. For those that are not familiar with us, we're one of the premier companies in the state of Florida. We have offices all around the state to service your needs, and a little less about me and a little bit more about the questions. So let's get going and jump in. I'm sure we'll have plenty of time to answer questions and talk about, how people can, get some information here to help their associations.
In true Bruce nature, we love it. All right, let's jump in. But before we do, let's kick things off with a poll question. How familiar are you with the covenants in your community association? It's a very important question. So we're going to ask away. How familiar are you with the covenants in your community association? We'll wait a few minutes for our results. And while we do that, Alex, I see you. Can you hear us? I think he's still working on it.
Says, I hear you, but I think we should just move forward.
All right. So let's continue on. All right, so we'll wait and share the poll results in just a little bit. All right, so let's kick it off this afternoon. Gary, what are the most common misconceptions about covenants in community associations? We'll kick it over to you, Gary.
Thank you, Zuli. No pressure. Well, listen, I think one of the larger concerns is, and talking in the friendly environment that we're in right now, is understanding, and again, challenge as the association lawyer, and I'm responding more as an association lawyer, is having the clients understand what we're really dealing with by way of, what are the documents, what are the statutes, and, the limitations. I was on a call earlier today with a very good client, been representing this towered condo for quite a long time. The answer to their question was, we have to follow the documents. The answer that the manager wanted was not to follow the documents because it didn't make sense under the circumstances, but we have no option. So, it's setting expectations is probably the bigger concern, Zuli, to your question, with what is presented and provided to us through those controlling documents. Would you like me to review that quickly, Zuli?
Absolutely. Go right ahead.
So just so everybody's aware, so from a statute standpoint, there are several statutes, and they definitely differ based upon whether you're in a homeowner association, in a condo association, and then we have some that are not in either, and they're in a non-for-profit association typically. But the statutes that we have to rely upon line up to the nature of your property. So for example, a non-for-profit association would follow Florida Statute 617. A condominium association would follow, from a statute standpoint, Florida Statute 718, and a homeowners association would follow Florida Statute 720. In addition, particularly for condo associations, there's also an administrative code, which is 61B 15 through 25, which provides added legal information and restrictions and guidelines with regard to the operation of a condo association. So there are specific condo, homeowner. I'm not focusing on co-ops, would be Florida Statute 719. We're really not speaking about them today. But there are, in the context of what is out there, condo, homeowner. And then when you say non-for-profit, where that comes in more than anywhere is usually sometimes a master association, maybe under neither 720 or 718, based upon how they've been orchestrated and the content of what makes them up. So that's the first issue, is that we have to look at the proper statute in order to define, and not every statute is defining on every issue. Sometimes they are. Sometimes, based upon whether, again, they have this famous Kaufman language, which is whether or not the documents are to be read in accordance, if they do have Kaufman, with the current state of the statute as amended from time to time. If there is no Kaufman language, which is a Florida case, if there is no Kaufman language, then you would refer to the statute at the time that the documents were drafted or amended based upon this situation. So again, what are the documents? There are controlling documents in almost every, either we'll talk about homeowner or condo association. Those controlling documents are the declaration of condominium for a condominium, or a declaration of covenant for a homeowner association. They are the articles of incorporation, which actually create the corporation, like any corporation in the state of Florida. In that, which is probably the most important reason to look at them, there are generally definitions, and there are also voting rights that are established, which need to be referred to, because the voting system for the property, and I'm not talking about electronic or not, I mean the actual who has what voting rights, is usually established in the articles of incorporation. The next document would be the bylaws, which are your operating documents. They typically tell you about your meeting structures, your budgetary obligations, things of that nature, your elections, all of those types of things, including board of directors, rights and procedures, are usually defined in your bylaws. Those three documents, declaration, bylaws, and articles, are amended generally, most of the time, stereotypically, by a vote of the unit ownership. These are recorded documents that are recorded in the county for which your property exists. These are documents that typically run with the land. So no matter how many times your unit or home sells, the documents run with the land, not with the unit. So those documents are going to stay in effect with regard to that property until such time there's a termination. The last document in that series of documents, which is the fourth document, are rules and regulations. And I like to think of rules and regulations as a supplement to your other documents. They're not documents which create a right, but define a right or supplement the use rights through that document. Rules and regulations are typically able to be modified periodically by the board of directors. They do not require unit owner votes. And the idea, again, is they're not creating rights. They're just defining some of the rights that have already created in one of those other documents. Generally, it's the declaration. So, using a quick example, and then I'll stop. Having the ability to have a pet, for example, is usually established by the declaration of covenant or condominium. How you walk the dog, in the case of a dog, how the dog is carried or not through the common elements, your obligations to leash the dog, things of those things beyond just the statutory obligations, where they would be defined would be in the rules and regulations. And the rules and regulations change periodically based upon the needs of the property. And therefore, that's why the board of directors is typically the one in charge of drafting and modifying rules and regulations.
Thank you, Gary. You actually covered a few of the questions that I had seen come in, and one of them was the hierarchy of documents. So with that, Bruce, quick question for you along the lines of what Gary said. So it's a lot of documents, right, to keep in mind, and a lot of information on the association level, both for our boards, but also for our management team. How do we help our associations keep organized or understand what applies to what area?
So it's an interesting thing that I talk to our clients about, and when people talk about these documents that Gary went over, if you're buying a condominium or you're buying a home in an HOA, you have to understand what you're buying into, and you have to understand, that you're just not buying your house, but you're buying into a community and so forth. And that goes true for a condominium, and it even goes even further when you're a board member and when you sit on a board, how important it is to read these documents and to understand your obligations of what you're required to do as an officer or a board of director. We all know that sitting on a board, everybody has an equal vote to vote in it. And you have to understand what you're voting on. Statutes have changed and liabilities, and, of course, Gary will get into it. They've changed. Board members have become, more responsible, have more liability on them to do the right thing by their associations. From a management company standpoint, what we believe in is having these documents and educating our residents on them, and especially educating our boards on them is very, very important. So having them up on your website, having certain stipulations of these different areas. Gary was talking about pets, which is such a common, thing that's out in the industry, educating the owners in regards to not just the covenants, but the rules and regulations of your pets and so forth. So those are the ways that, we as management are responsible of making sure. So the big thing for me is visibility and education of those for both boards and residents of HOAs and condominiums.
Thank you, Bruce, and I couldn't agree more. And, we're going to talk about the compliance piece a little bit down further along in the session, but right now we're really talking about the understanding of the documents, the content of the documents, and you talked about liability, Bruce. So my next question, Gary, is for you, and we all know that from time to time, all associations have to make that phone call to you as the association attorneys or to their legal counsel to say, we've got an issue. So at what stage should the attorney be involved, and typically to what extent?
Interesting one. look, the reality is that kind of buttressing off of what Bruce was saying, the statutes are changing. They just changed again this year. We had 191 pages of legislative changes for the condominium world this year. Following these requirements, these statutes, these amendments, and then understanding them, and then actually at some point either seeing how they're going to be applied. It's very complicated. I've had the good fortune of speaking to a few management companies since these new legislative pieces came in. And as much as I can dictate to them what the changes are, the reality is how they're going to apply, how they're going to be interpreted is a different story. So look, the reality is, in my view, boards of directors should not be judged based on how much money they spend with their lawyers, if they're being reasonable and practical. What they should be judged on is how they're moving forward with issues, directives, their obligations, their duties. If they need to consult with their attorney to get their best information to guide them, it's built into what their obligations are. That is the right thing to do. Saving money and saying, you know what, we have an issue regarding an interpretation of something. We just made the interpretation ourselves. We didn't seek advice of our professionals. That really doesn't benefit anybody.
Right.
You know, there's a flip of the coin on that one. And frankly, if I lived in a community association, I wouldn't want my board members to apply their own judgment only. I think that if they need guidance, they should seek guidance from their professionals. So I think when it gets to the point where you can't make a decision based on what's in front of you, that's when you have to consult with counsel or CPA or management or engineers or project management, whatever the case might be.
Absolutely. The same holds true to all of the professionals, right, that you partner with.
Right.
Now, oftentimes we find that governing documents they have outdated language. They may even have some developer references, or they have not been amended since the inception of the association, which may be X number of years, 15, 20, 30 plus years. So this question has actually come up a few times prior to this session and on our chat here, Q&A. And it's how often, or how frequently should bylaws or documents be updated or reviewed?
So look, I think particularly when I take over a new client relationship, a new, representation, I'd say 50% of the time, part of that initial discussion is, hey, we want to modernize or improve our documents. And it kind of just is like a thought. And I'm not saying it's not a good thought. My response to that is we have to figure out what you guys need. Because one of the worst things to do is just to turn over that type of assignment to whoever your professional is. The right way to do it is to have a very strong discussion between the client and the attorney to set the parameters of what we're going to be doing. What are the, sometimes it's just we need to change one or two items, which is an amendment to the declaration or bylaws. Typically not a very expensive exercise, and it may just address the problem. Coupled into that, maybe we don't want to read anymore about the developer this and the developer that. And frankly, that reality is expensive to do that, to go through the documents and to sanitize. I'm talking about an older association that is completely devoid of any type of developer relationship anymore. And you have to understand that relationship may exist way after the developer is off property. The developer may have rights that have to be evaluated. Developer may have a right to an antenna on a rooftop that, he's had or she's had for years and years and years, and it still exists. We can't possibly do that. That would be a violation for us to do that. And the benefit of also just cleaning up the documents for that purpose, the expense may outweigh the actual benefit. So those are the types of things we have to look at. We also have to look at whether or not the documents, the way they're situated, again, maybe there is a change as in adding or not, because there's good and bad with regard to adding in that famous Kaufman language. So your documents will be read in accordance to existing amended statutes. There may be some other tweaks to make to your documents which may envelop all the real goals that you're trying to get after without having to rewrite them in their entirety. So the best way to proceed to your point, Zuli, is your attorney should be having a fundamental conversation with your board. There should be a discussion as to what the goals are, and expectations should be set, and it should be a marriage between the association board and the attorney to figure out what is the most effective way to get to the end result. And that may be, again, a series of amendments. It may be sections that are amended. You know, rarely is it that we have to do an amended document where we actually replace document A with document B. It does happen sometimes,
Right.
but it's rare.
But Zuli, can I add to something? And I
Absolutely.
want to add something to what Gary said. Gary's talking about really the technical way of doing things and how to look at it. I want to look at this in a practical way, okay? And
Are you saying
especially,
I'm not practical, Bruce?
I think that's what he said. I
I
don't know.
thought that's what you just said also, but go ahead, it's possible.
I'm
I've
going
been
to
playing
talk.
lawyer all day today.
You know, this is no easy task. So I want boards to ask themselves a question. If you are going to engage someone like Gary to sit down with you and do this, this is really a process that you have to go through. This is not an easy process. Remember, changing these documents is just not a stroke of a pen and Gary's going to give you advice and you're going to put it in there. You're going to need a vote, and you're going to need the majority of your association to go through this, and your declaration is going to tell you what you need to do that. So if you're out there and thinking, oh, this is just, oh, very, very easy to do, it's not. It's costly, but I definitely think that if you're going to do it, it can really benefit the association, especially new associations going forward, but old associations to catch them up with the times and so forth. So you have a good attorney that's going to advise you. You have a good management company that will help you get you through the process. So remember, we've got to put the plan together and the process together, you know, and make sure that our efforts are going to be successful. Okay. The rules and regulations and changing that, that's easy. We're not going to get into that now, but what Gary's talking about, it could be a lengthy process. It could be a difficult process. So if you're in, then you got to be all in for it. And we got to make sure that everyone understands what you're going to have to do to make this really happen, because the idea to come out of this successful is what everybody wants.
Well,
Gary,
Right, I will, oh, I'm sorry. I'd like to add something to that, Gary and Bruce, if I may, to your point. The practical or the fundamental behind the scenes approach to this before you get into the actual legal process is also education and communication, and allowing the process, if you were to venture into an amendment change or document change, it's no different than if you were changing your rules. But in this case, if you are wanting and needing the buy-in of your community to vote yes to a change that is going to benefit everyone, and you want to allow enough time to educate everyone around the process and why it's a good idea. Do not wait until they have a document in hand to inform them of the change, because a lot of times you find that that is not a great result for anyone. And then you have to repeat the exercise over and over again. So we almost every time from a management perspective want to allow enough time so that all of these steps can happen successfully. Because again, the goal is to have a positive result. So, and communication and the buy-in of your community is critical. Gary, go ahead.
Liz has a question here. Is there any reason not to incorporate the Kaufman language?
Yeah, there's some associations that find that being bound by the new statutes may not be to their best interest. There's certain, you know, it's a large undertaking. There's a lot of things that come in with that. It matters how their actual documents are structured. That's something that needs to be evaluated. So you need to look at what, you know, how your documents are designed, how the building property is operating, and whether or not Kaufman is advantageous or not. Under the circumstances. Usually it is, but it's not always. There have been some associations where there's been some really big disputes between boards and owners as to whether or not the statutes, you know, really are beneficial, all of the statutes. Because again, there's an issue between what Kaufman brings in. It's more substantive statutory requirements, not the procedural things are going to be applied anyway, but that's the general interpretation. So it gets very specific, and it's really something that you really need to have a very deep conversation with your counsel over to figure out what's best for you. But Zuli, I wanted to add one piece to what you were saying, because it it's opened up quite a bit of points and thoughts on this. But look, Bruce, what you were saying is correct. There needs to be a practical, commonsensical discussion from the inception as to what your goals are. That's what I was trying to say. Meet expectations, figure out what you guys really want to accomplish. The next step, though, which is important, is that if you decide you are going to move forward, how is that going to happen? Are you going to leave it up to the board with parameters? Are you going to create a committee? And I've seen committees, well-intended, thinking they're going to be looking at, 2 or 3 items in the bylaws, and they come back 3 months later with pretty much a brand new set of documents, in their mind. And arguably, a huge percentage of that may not even be able to be achieved because they're not within the statute, or, they're conflict with some of the provisions of their documents. So, we want to make sure if you're going to use a committee, the committee's properly charged. They know exactly what they're going to be doing. There should be a scope of work, how long it's going to take. If it's going to be the board needs to understand that. And again, it's a working segment, it's a working relationship with council to figure out how to move. And then once you do move to the point where you're actually putting draft to paper, now, Zuli, your point's great. You need to have potentially some town halls or board meetings where it's just being introduced, so people have a understanding where you're going, particularly if there's going to be some sort of significant change. So back to Bruce's general point, it is a process. And I'm not talking about just doing an amendment. I'm talking about if you're doing, a series of amendments, there's definitely a process involved. And if you don't do it right, there's a likelihood that it's not going to be successful.
Thank you both. And Alex, welcome.
Thank you.
There's a question here that says, are changes to statute 718 automatically incorporated into the declaration and bylaws?
Again, that goes right to this discussion about this Kaufman language, which comes out of a case that was decided in the late 70s. And that language needs to be in your document, which would bring your documents to be read in conjunction with the current state of the statute. If that language isn't in your document, then you would be reading the document as per the date when the documents were initially recorded. So that is exactly what we're talking about when we refer to this Kaufman language, and whether or not your documents incorporate that or not.
Okay, wonderful. Alex, do you want to take the next question?
Now, Barry has a question. If the condo deck doesn't include the pre-Kaufman language, can they still suspend the use rights and the voting rights for?
Again, but Alex, I don't want to get into the specifics of that, because that's really requires a document interpretation, and I don't think this is the right form for that.
I think we're going to jump into violations. It sounds like a great time to do that. Violations, I think, the whole compliance piece in an association, it can be complex and many times misunderstood, right? Sometimes there are associations that don't know whether they need to have a committee. So just perhaps to start, just an overview of the process in order to actually execute a fine and what that would look like, or even the violations process and how to really interpret that in the documents.
You want me to take that?
That would be you, counsel.
Okay.
That would be you, counsel.
All right. So look, the overall analysis, really, if somebody's in violation, the violation itself is obviously a huge subject matter to how we're going to react as a community association. Very often management starts a letter writing campaign or a notice campaign to the owner, letting them know about the violation. That could then graduate to the attorney. The attorney can write a letter or two based upon the nature of it with additional warnings and clarity. I would certainly suggest that at a certain point, a time limit has to be afforded for that violation to be cured. Once that happens, and assuming the owner or tenant, but it always goes back to the owner, fails to comply, and now the question becomes, what do you do? And that will change, obviously, based upon whether you're in a homeowner association, because under that set of statutes and documents typically, versus a condominium association. So, again, the association council can certainly get involved. I would tell you that if your association attorney is aware as to how these letters are supposed to be structured, we often see compliance between the management company and the attorney letters, I would say at a pretty high degree. I mean, we have a high percentage rate of success when there's a letter writing campaign. If it's not successful and we have now a unit owner who's non-compliant, the association has options. So options include, again, documents are going to be important to read, but assuming you have proper language in your documents, you can proceed with a fine, which requires a board approval of the fine, followed by a grievance committee or fining committee meeting. That's going to happen under condo or homeowner association, where a notice is going to be provided, 14-day notice is going to be provided to the owner ahead of the grievance or fining committee meeting. And then after that, there will be a, if approved by the board and ratified in essence is really what the committee ends up doing by the committee, then the fine would then go into effect. Fines are typically $100 per day up to $1,000. That's what the statute authorizes the associations to provide. They're a good source at the grievance committee, the fine. They may have an impact. Also, you have the right through the grievance committee under these violations to also have use restrictions applied and voting rights removed. So there's some serious rights that are available to the boards and the committee in order to try to effectuate compliance. Then what? Well, under the circumstances, again, whether a fine or a use right being restricted or voting right being restricted, I think it all has a lot to do with what the violation is. So you have to look at what's going on to determine what course of action you're going to be taking. Because, I use as an example this scenario, and it's a true scenario. About 20 years ago, a beautiful association that I represent in the Miami Lakes area, around a beautiful lake. There's a water feature, about 88 units, exactly the same. It was a condo association, but it doesn't really matter. The property was built, developed, beautiful. All the colors were synchronized, roofs, everything was synchronized. Architectural control committee in existence, whatever the case. Waterfront properties, and one of the unit owners decided that they wanted to put in an awning. Their documents had a restriction that the awnings were able to be put in the back of the home, but it had to match with the roof color, which was terracotta. This gentleman decided to put in a striped, I think it was a green and white striped awning, which had no color coordination to the roof system, in complete violation of the documents. They contacted me. The association was given directions. We had this exact conversation about whether or not it would make sense to fine or going through their grievance committee, or it made better sense potentially to take a legal action against the owner. After the notices went out and the demand letters went out and there was no reaction, it was about I think at that time about a $5,000 or $7,000 installation. The unit owner did nothing. The board wanted to stay friendly. I understand that. They decided to just go through the grievance committee process. They did not initiate a lawsuit. My comment to them was, at a certain point, they had really to proceed with a legal action, because failing to enforce was, one, going to prevent this owner from removing his awning system, but more importantly, was going to probably have a negative impact on the enforceability by the board, in that case, with regard to the other owners on the property who are going to want to make changes, either that type of change or something else. If you go to that property, it's been a few years since I've been there, but the last time I was there, which was probably about 5 years ago, you wouldn't even recognize, not because of failure to maintain, but based upon the amount of changes that were made that really came out of that initial failure to enforce. Then it was another, change and another change, and somebody else did something else. And then there was no ability really to rein that back in by the board of directors, because there were so many changes that the documents really weren't effective. Now, there are ways, which I know is an issue, how to reinstitute provisions in your documents and to start enforcing again. But there's a practical reality to that based upon the situation. So you have to look at the degree of what the issue is. You have to look at the cost associated. Yeah, a unit owner who's dragging their garbage down the hallway and making, a mess of the carpet will probably react to a $1,000 fine. But if you're investing thousands of dollars into something, or it's some rational, in your mind, some rational reason why you're doing something which is in violation, it's a hard one to necessarily relate a fine to. The fines are good if they're going to serve a reaction, but a lot of associations just defer to the fining system. There's $1,000 fine. The boards don't move on trying to collect them. And, 10, 15 years later, which is the story of that particular unit, that unit owner that I just mentioned to you about that community still has that striped awning. He's replaced it about 3 or 4 times over the years.
It's the
But
same
that awning
style.
still exists there.
Yes.
Sylvia, would you mind
Can
me,
of
would you
worms,
mind me
right?
adding into what Gary said,
Go ahead, Bruce.
about what this whole program, when people say fining or
Mhm.
and so forth. I mentioned it earlier. When you buy into a condominium and you buy into an HOA, you're buying into the rules and regulations that everybody in the community has to live by. This process that Gary's talking about is not to, by the way, some boards say it's to generate money. It's not. It's to get behavior, people to act with the right behavior in the association. Just like Gary said, when you have someone that is not behaving correctly, you're trying to get it in line. You're not trying to go happy. You're trying to enforce so that the community lives under the covenants and the rules and regulations that everyone bought into. I also want to mention something else that Gary talked about, especially from a management end. It's really important that if you know your rules and regulations and you know your violations, all of those letters should be checked by an attorney to make sure from a legal standpoint that they fit in line. There are associations that use them as templates, okay? And once you really have the wording and it's correct, because you're really taking the wording out of the declaration and you're using all that. So I highly recommend that you just, a case you get into a situation like this with Gary, this is how the cases start, that you have all your ducks in a row. And by working with your attorney from a management standpoint, that's just going to set you up so that, really the problem is resolved and people take them seriously. Because some people, will take these fines and say, you know what, no big deal. I'll take the $100.
Mm.
Or, different things. They'll just throw it in the garbage, big deal. Or there are some people that say, oh, just fine me, I'll just pay the $100. So there's all these different behaviors that
Right.
happen when you get these violations and so forth. And that's important to make sure. It goes back to education also. Gary mentioned grievance committee and so forth. The importance is of having a committee of their peers within the community set. And this grievance committee understands what their job is. And that's another thing. Management should be able to educate it, or their attorney should be able to be brought in to say, well, if you're sitting on this committee, you got to take it seriously. This is no joke here. You've got to hear. It's a hearing here. It's not just to do it because you're just sitting there looking pretty. You're really trying to understand what the issue is and to try to help your fellow neighbor out. So if you're sitting on that committee or you're doing things as a board, just take all this into consideration of what we're talking about here today.
Thank
Yeah,
you, Bruce.
go ahead, Zoe.
No, go ahead.
No, what Gary said is once you open up that can of worms and you allow it, it just turns into Wild Wild West. To enforce it later in the future, it's very hard, and your real estate values go. The place starts looking horrible. You moved into that HOA because of the look, the way it feels, and it's just don't let it happen. Bruce? What are you seeing? What's to enforce these rules? What are the best practices you're seeing out there? So if you have an on-in situation like what Gary was talking about.
Look, large HOAs, they actually have a department or departments that go out there, and they're called covenants departments and so forth. They're there to educate, and you have to educate owners, and that starts when they first enter. If you're not having a homeowner's orientation, it starts from the beginning, the minute you enter that community, and educating them, Alex, in regards to what they can and what they can't do. I saw something in the chat about ARC committees. They're set up to do things like Gary's talking about. Make sure you have a strong committee that works in conjunction with them to make sure that they're enforcing the architectural modifications that are allowed within the community, paint colors, awnings like Gary talked about there, that's important there. But it goes back to those covenants groups that are on property, or if you have management companies that come in and do it, is to start really educating, the community of what they can and what they can't do. And when it comes down to, like Gary is saying, the garbage, sometimes it's just a conversation with the owner. Look, I don't want to have to do this, but the next time I'm going to have to do it because you're violating this policy. But again, different communities work different ways. Sometimes it's a very simple thing. And I'm sorry to say, sometimes it's a sledgehammer that has to come down immediately to just shut it down right away. And that's just based on the community of what's there. You don't want the wild, wild west, Alex, like you stated. You don't want that in a community.
Jason has that question: who's responsible for enforcement? Is it the board? Is it management company? Is it legal? Is it the committee? Who?
Can I answer that very? Can I answer that very? Can I answer that very?
Sure.
It's everyone in the community that's
Mhm.
responsible to enforce the policy. We all live under that. So I'm going to give it to Gary. He might have a different answer, but in my opinion, it's all of us. We all have to watch out for each other that live in that community and do the right thing by your fellow neighbor. Okay, Gary, I don't know if you have a difference of opinion.
I don't disagree with that point. I think that generally the reaction as to how to best enforce is going to be looked at the behavior that's at issue, the issue that's presenting the concern, and there has to be a conversation, and the board should obviously again establish their own expectations on the results. You need to temper your reaction for enforcement purposes based upon what you're trying to accomplish.
Yeah.
But in that same spirit, there is a situation at times where the association has to proceed with a legal action. It's not something we do a lot, but we do it because there needs to be a reaction. I'm not just saying to set a precedent, I'm saying because of the actual issue. I mean, there needs to be an action in order to seek compliance with the documents, and that's going to be defined by this situation. Note that typically the attorney's fees are going to be paid for by the party that is the losing party. It's called the prevailing party provision. So the prevailing party is going to have their fees paid for. That doesn't mean that the association doesn't need to pay the law firm. It just means that when the case is resolved, that the money is going to be hopefully reimbursed back to the association through that process. So that's an important task. But I do want to also make mention of one other thing, which is much more typical predominantly in the condo market, but it could apply in a homeowner association as well. There's also an ability for a unit owner to have an issue with the unit owner that is going to be addressed by the unit owners. And we get into that situation very often. A lot of times it has to do with damage between units that are in a line. But there's nuisance issues that come up and other issues. And,
Right.
The full reliance on the association, going to the exact question I think that Alex pointed a moment or two ago, on the association always being the one that's being perceived as the party that's responsible, it's not the case. So there's nothing preempting an owner from having a concern or a legal issue and addressing it through their own means between owner to owner. And sometimes it has to be done that way because sometimes the association doesn't have enough to actually step in and become an enforcer or to be an involved party. Doesn't mean that they may not get sued if one owner sues the other owner, but it does mean that the association sometimes just isn't the proper party to seek enforcement. It matters. So the circumstances that exist are going to matter as to who's going to be the party to institute, initiate, and possibly be involved.
Thank you. I think what I would add to that, I think you've all covered great points, would be the reasonableness right behind the rules and the policies that are applied and enforced, and the consistency. Because again, if you have the perception of selective enforcement, it could get away from you. It's the perception that your community has of the board and how they selectively enforce rules for some and not for others. So consistency is definitely key. And to Bruce's point, education is paramount, and it's from the beginning, having that information in your new owner welcome, even renters, if you have renters in your community, because again, the rules of the association and the expectations of behavior apply to everyone in the community. Alex, take it away.
So, Gary, you've gone through these rule changes, right? And document changes. You have these experience. What are the effective ways to communicate these rule changes once you get the vote and you've gone through the whole process?
Well, listen, you need to obviously be, your obligation is to provide the rules ahead of the voting. I mean, there's a question about particularly, whether the rules that affect the use of the unit or not. I tend to recommend that we do as much, pre-notice to the ownership as possible with regard to any rule change. So everybody's aware, particularly at the meeting when you're going to be approving a change to the rules, that everybody's, let's get it all out at that meeting. If there's a committee that's been assigned to that, obviously those committee meetings need to be noticed as well, under both conditions, board, or whether it's a homeowner or a condo. So, educating the ownership as to where we're going, using that word again, is always helpful. Obviously, after the rule goes into effect, giving everybody sufficient time. Some documents require it. It matters what your documents say, but to provide a copy of the newly adopted rules once approved to the ownership ahead of enforcement, with directions that this rule is going to go into effect within 30 days or some other time frame, is very important as well. And I would highly recommend that as a step to be taken. And it's getting to the point of where the ownership are aware of what's going on. It's very important. So it would come up at board meetings. It can come up at future board meetings, future notices, newsletters, however it's going to be able to best be presented.
Bruce, is there a best practice, something you've seen on site that's done once the rules change?
Again, if rules change, then there's an education process of doing that. And it's just not when it happens. If there's a rule change, I think you need to give, not a considerable amount of time, but a reasonable amount of time to make sure that people understand it. So when I say a reasonable thing, if something's going out there, if you're sending emails or putting it in newsletters, or you're doing things of that nature, if you give a 2-week period and say, look, after the 2-week period, we're going to really enforce this, that's really probably the best way to do it. And so that people are not taken surprise. Again, this is not about being bad. This is about, look, we're educating you that you're doing something wrong here, and you just need to fall in line with, what you bought into. And I keep going back to that, what you bought into as a condominium or an HOA.
So we are getting close to time. We do have the response from our poll question earlier. So we're going to go ahead and share that now. All right. So the question was, how familiar are you with the covenant in your community association? 60% said very familiar, which is wonderful to see. 36% said somewhat familiar, and 3% said unfamiliar, which is okay. And I think we learn every day because, as we know, you have different things that come up at a different time, and you may not be very familiar with a certain rule or application. I can tell you one area that tends to be sensitive in our associations from time to time is records request. And quite often we see the recommendation by association council or even us as a management team to create policies or rules around that, right? So that it's clear and apparent. So I don't know if we want to cover that as well, just maybe as a tip for associations that may not have a documented policy around records request.
Well, I'll just jump in and say, the statutes allow you to set certain parameters around records requests. It's a kind of fundamental right for an owner to be able to request to inspect records, not necessarily have them handed to them, which is a confusing piece. People think that that's the obligation. It's not. It's to establish a meeting within 10 working days, business days, for the unit owner to come and inspect the records and then direct management, typically, as to whether they want them copied or not. They can bring their own copy device in to do it, scan it themselves. But to your point, it is very, very common practice that owners sometimes abuse that right. And so how do you, the state has defined that you're allowed to put out reasonable rules and regulations. There's actually just a brand new case that further defines, it's always being tweaked, what those rules and regulations can look like. So unfortunately, I'm not going to be able to be in a position right now to say this is exactly how it works.
Sure.
It's going to be defined and designed based upon, what the scenarios are on property. You can't, for example, restrict it to one time a month. That's been viewed as being, too oppressive in that regard. But again, those are the types of things that are always being addressed through case law as to what you can and can't put in. So your lawyer should be able to help you put together a defensible, supportable policy. But what it really does is it establishes frequency, duration, things of that nature, so, and some limitation on what, how much can be provided, because unfortunately people take advantage of the situation, which creates a paralysis by the management office or whoever oversees your document maintenance. So there are rules that can be afforded, and those rules would be approved by the board of directors.
Can I just add, Zuli, we were honored to have Gary just recently last month at our managers meetings to discuss the new changes in the statutory law. Did a great job. This is a requirement of our managers, but we look forward when he does things like that for us as a company to educate us so that we could go back and educate our associations. One of the big things that I took away, and especially our council, is that the website. Use the website as a tool. If you're using your website as a tool of loading, and there's a lot of changes, and Gary went through, he gave you 109 pages, if I remember you just saying that. There's a lot of changes, okay? So the bottom line to it is use your website, get the things up there. If your website is really, populated the way it should be, it should eliminate the time that people make those requests. It should eliminate, think about the money that you're going to save as an association, the time your manager is going to save. So just keep pressing that website and, just understand it's getting, our friends in Tallahassee are getting tighter and tighter with these record requests now. And they're not easy record requests these days. They've taken up a lot of our time as a management company or as a manager on site.
Great point, Bruce. Transparency. And the more information that's out there, the easier it becomes for residents to have access, right? And the questions, even at board meetings, may not be as intense if they have access to information. So Alex, we are down to the countdown on the final 6 minutes of our session. Any final comments?
Okay, I'm getting text messages here from clients, Gary, and somebody's asking me, is there any legislative changes you'd like to highlight that you have on your?
Listen, again, there was a lot that came in this year. I don't want to, my only hesitation is I don't want to say some that are, that's a whole session. We do a 2-hour, seminar, webinar on that. It's available all on, no plug intended, but we have all of it. We just updated all of our legal updates, which is a 4-hour session. So I would best recommend, instead of just mentioning a few and skipping some that may be important to each particular association, I would just recommend, please do your update. You're obligated to do that. If you don't, you're not obligated. You don't have to take it. It may just be wise for you to jump on it anyway and to see what the changes are. They are very significant. There was a lot involving CSRS this year. Again, being able, how to best fund them in the condo practice, particularly. But there were a lot of other changes in with regard to even elections, some of the procedural requirements. Predominantly condo, there was very limited, if any, real changes to the HOA statute this year. There was much more last year. So if you're in a condo and you're interested in seeing what's going on, I'd recommend you jump in on that. You can fast forward through some of that stuff, but that would be the best way to respond, Alex.
Perfect. And in a best case scenario, I know we got 4 minutes here, and I wish I could ask all the questions that are coming in. We'll respond to everyone here. Best case scenario, how would you like to see association run when you're handling these kind of situations in your point of view? How you look at it? What is the best case scenario?
Are you asking me that question or any?
You,
I don't understand the question. So
If-
I would need
if-
somebody to.
If somebody's
Find it
breaking
out.
a rule, what are the steps that should have been taken? What should have happened to be able to enforce the rules?
Well, again, so trying to maybe summarize a lot of the conversation that we had here today. First, it's important to get the rules out. And when I mean rules, I mean the documentary requirements need to be presented. And there are a lot of associations that don't go through the step like Bruce was mentioning and actually start at the beginning and have a sit down and do some sort of, introductory meeting or however you want to call it with a prospective new purchaser. They're just not doing it. So I think that's very critical to
That's a
start
good one.
with
Yep.
the information and get it out as a package. Some associations require a signature that says that you've read it or whatever the case might be. But again, that'll be dictated by the terms and conditions of your approval process. But that's important. I think next is when a violation occurs is to present it correctly. Look, as a general comment, doing this as long as I've done it, I have to still say that the communities that in my mind are the most successful community associations are the ones that have some certain level of enforcement of their terms. Generally, associations that don't do it are ones that have the most issues. They may have them now, they may have them in a few years, they may have them down the line. But there's a general sense, and again, I'm not advocating commandos. I'm not saying that you have to be overzealous in your enforcement. But I am saying that people that buy in a community association fundamentally understand that they are buying something that is going to be regulated. Either it's visual, it's either going to be, architectural, it's going to be a behavioral, but they're not buying in a single family home. There's good or bad, they're not. And so there's a certain degree of consistency that needs to be applied, and those things are really important. So, when the violations start, based upon the degree of what's going on, to start a letter writing campaign, trying to inform them. I'd also advocate, picking up the phone if there's time for that type of thing and based upon what it is and trying to communicate directly. Sometimes the person just doesn't understand. They just don't understand what the restriction is. Look, there's a lot of people who buy in the community association marketplace and they don't understand what they're buying.
Absolutely.
They just don't understand. They've never lived in one before. So they don't, oh, is that really true? I mean, is that, yeah, but that revelation moment is something that we got to get past at the beginning. And then you got to be consistent. I mean, there's got to be, Zuli used that word, there's got to be a level of consistency. If you're going to apply parking restrictions, you're going to have to apply parking restrictions against anybody. It doesn't mean that if you're applying parking restrictions, because that's the most important thing, you may be a little softer on something else. I'm not encouraging that, but I'm saying not everything can be enforced at the same level. And Bruce, you made a comment before, and I'm going to stop, but you made a comment before about how rules and regulations are done. Look, if you're going to come in with a full-on set of new rules and regulations, including, parking and party room usage and pet rules and use of common element rooms or common area rooms and, ARB or ARC restrictions. Some associations do a huge revamp. It's going to be a hard one. That's a hard thing to tackle because the more you put out, the more difficult it is to seek full enforcement. So know that as you're delivering this material, you need the ownership to understand the extent of what you're doing, and you may need to, layer this out at some degree because it's sometimes too much for a community to handle.
Gary, I just want to add something. This process cannot be selective. You got to be in, if you're a board, you have a responsibility to your residents, to your community, to uphold the declaration, the rules and regulations and the policies that have been set forth in your community. So, when you start to pick and choose what's right, what's wrong, everybody has to be treated equal and so forth. So please remember that. And remember, if you're doing that, what's good for you is good for the next guy in the community and so forth. Remember that. Do not be selective. Everybody's the same.
It's a great closing statement there, Bruce. Thank you. Gentlemen, I know we're over by a couple minutes here. Thank you for today. It was very informative. There's a lot of questions here we're going to answer afterwards. Jason, email me afterwards. We'll probably be able to help you with that, with the question you have. And on behalf of, Zuli and myself, thank you for joining us today, and we'll see you next month.
Thank
Thank
you,
you, guys.
everyone.
Thank you,
Great
everyone.
session.
Appreciate it.
Bye.
Have
Bye.
a great day.